Good morning, everybody. Welcome to another episode of Subro Sessions. My name is Zachariah Sigda. I'm an associate in the subrogation department here at White & Williams, LLP. And today I am joined by my talented colleague, Katherine Dempsey, also an associate in our department. Good to see you today, Katherine.
Good morning, Zach. Good to be with you.
So what are we talking about today, Katherine?
So today we'll be discussing the Made Whole Doctrine and more specifically how it applies under Texas and Washington state law. An insured has a common law right to be made whole for a loss before the insurer may be reimbursed for a coverage obligation to the insured out of a third-party recovery only if the recovery was made by the insured and it is the insurer that is seeking reimbursement. Essentially, the made whole doctrine is a limitation on the insurer's right when it seeks reimbursement from its insured out of a third-party recovery obtained by the insured. The made whole doctrine is a default rule that is read into insurance contracts, except where it is explicitly excluded. With that being said, Zach is going to explain how Texas addresses the made whole doctrine.
So the first case, or jurisdiction, I should say, that we're looking at today is Texas and how Texas courts deal with the Insured Made Whole Doctrine. So in 1980, the Texas Supreme Court, in a case called Ortiz versus Great Southern Fire and Casualty Co., really dived into what the Insured Made Whole Doctrine means under the principles of equity. This is absent a contract provision saying that the insurance carrier has a right to recover losses that they paid out through subrogation investigations. So the Texas court held that when either the insurer or the insured must to some extent go unpaid, the loss should be borne by the insurer, for that is a risk the insured has paid it to assume. So when we're talking about principles of equity, we're talking about public policy and what's in the interest of the public good. And here, the court is basically saying that in a scenario where either the insured is going to be made whole or the insurer is going to be made whole, but not both, and absent a contract provision or a statute that says otherwise, the Texas courts are generally going to side with the insured, and they are going to make sure that the insured is the one that walks away from the loss made whole. And this makes sense. The insured pays premiums to their insurance carrier, and you purchase insurance to protect yourself from risks. And so under the Texas courts, absent a contract provision or statutory language that says otherwise, they're going to side with the insured. Now, when the Texas courts have, especially in 2007, in a case called Fortis Benefits versus Vanessa Cantu and Ford Motor Company, the Texas court weighed whether the insured's made whole doctrine arising under the laws of equity supersedes or should be in front of any contract provision or statutory claim that would say that the insurer should be made whole. So generally, what this court held is that contract rights are established under the terms of the contract and that they take precedence over the rights established by the equitable made whole doctrine. One thing that you can think about here is that generally they adhere to the maxim that equity follows the law. So if the law or the terms of a contract say otherwise, that will supersede anything that they have said previously about whether the insured will be made whole under the principles of equity. So in this case, this is the term that was included in the insured's policy. Fortis will be subrogated to all rights of recovery a covered person may have against any person or organization. The provision continues. Such right extends to the proceeds of any settlement or judgment, but is limited to the amount of benefits Fortis have paid. So in this case, Vanessa Cantu got into a very bad car accident and she suffered serious medical injuries. Pre-trial, her insurance carrier agreed that they would only seek to recover any amount paid to them under the policy directly from the insured and not from the manufacturer or anybody else that was involved in the litigation. So Cantu was awarded a judgment. She got paid a bunch of money. However, when Fortis came along and tried to recover the amount that they had paid in medical benefits, Cantu argued that she was not, in fact, made whole because the injuries she suffered were going to require ongoing medical treatment for the rest of her life, and that those damages, or the amount that she would have to pay for that ongoing medical treatment, was more than the amount that she was awarded in addition to the amount she was paid under her policy. And the court said that because there was a provision otherwise in the policy, namely that Fortis will be subrogated to all rights of recovery a covered person may have against any person or organization, that they were entitled to recover the amount in excess that would cover the amount that they had paid for medical benefits to Cantu. Now, one thing that everybody must remember when dealing with Texas is that the Texas courts are very sensitive to the one satisfaction rule. And the one satisfaction rule basically means that the insured cannot double dip or have a double recovery. They can't recover from both their insurance carrier and the defendant. They do not want them getting paid twice. It's to avoid a windfall, and the courts also signal that they're worried about fraud in these situations. So whenever you have a claim in Texas that you are working and the insured has been paid for the damages that arise out of the injury, either from a defendant or a target, and have been paid by their insurance carrier, you should use the one satisfaction rule to ensure that your client is able to recover. You can point to the fact that they've been paid once and that it's not right for them to get paid twice under the one satisfaction rule. And you should generally be able to recover that amount for your client from the insured. And that is a wrap on the Insured Made Whole Doctrine in Texas. Now we will switch to Katherine, who's going to discuss how Washington State applies the Made Whole Doctrine.
So, under Washington state law, absent contract language to the contrary, an insured is entitled to recover his general damages from the tortfeasor before allowing subrogation, provided that in doing so, he does not prejudice the rights of his insurer. Regardless of whether the made whole rule applies or whether, in fact, the plaintiff has been made whole, this right can be modified by contract. The made whole doctrine is a rule of interpretation that only comes into play when an insurance contract is silent on the issue. To prevent conflicts between an insured and insurer, Washington courts have generally established priority for the interests of the insureds through the made whole doctrine. An insurer, therefore, cannot obtain a recovery if its insured has uncompensated damages. And here we have a case involving auto insurance policies. In 2019, in Daniels versus State Farm Mutual Auto Insurance Company, the Washington Supreme Court explored whether Washington Administrative Code 284-30-393, which reads, "The insurer must include the insured's deductible, if any, in its subrogation demands. Any recoveries must be allocated first to the insured for any deductible incurred in the loss, less applicable comparable fault." Here, the parties agreed that this requires an insurer to seek recovery of its insured's deductible as part of any subrogation claim against a third party, and that the insurer must return some portion of the deductible to the insured. The dispute between the parties was over the meaning of the final four words, less applicable comparable fault. Daniels, the plaintiff, argues that the applicable comparable fault refers to fault that is attributable to the insured. Under this interpretation, the disputed portion of the regulation is confined to circumstances where there's a determination that the insured is partially at fault. On the other hand, State Farm contended that there is nothing in the language that limits applicable comparable fault to fault that has been attributed to the insured. It would have us interpret the regulation such that the insured need reimburse its insured only for a portion of the deductible equal to the fault of the party from which it has recovered. However, the court interpreted the regulation in the manner intended by the agency, and in doing so, it is evident that Daniels raised a valid claim regarding violation of the Washington Administrative Code. Accepting the facts alleged in Daniels' complaint as true, there appeared to have been no assertion that Daniels herself bore any fault for the wreck, yet State Farm withheld 30% of her deductible. Ultimately, the Washington Supreme Court reversed and remanded the trial court's decision to dismiss Daniels' complaint against State Farm. Here, there can only be one reasonable interpretation per the court, which is one that aligns with the common law made whole doctrine. The interpretation State Farm urges, and which was adopted by the courts below, does not align with that doctrine, and therefore the Washington Supreme Court rejected it. The court accepted Daniel's assertion that the second section of the policy language prohibits State Farm from allocating subrogation proceeds to itself until its insured is fully compensated for their loss, which includes full reimbursement for the insured's deductible. Essentially, the court explained that this interpretation is consistent, as it must be, with the Made Whole Doctrine and the basic principles of subrogation, which emphasize the loss suffered by the insured. And under this interpretation, Daniels asserted a valid claim that State Farm violated that policy.
Thank you, Katherine. So the purpose of this podcast is to sort of point out that because we're subrogation professionals, we are tasked with making recoveries for our clients. And considering that our clients are insurance carriers, it's very important to understand how the Made Whole Doctrine is going to impact their ability to recover, especially when their insured has uncovered or unpaid damages. So this is just two examples of Texas and Washington where we have different interpretations of the Insured Made Whole Doctrine. The two examples of Texas and Washington show that the Insured Made Whole Doctrine is not uniform across every state. And therefore, it's necessary to review your insured's policy and to understand how the Made Whole Doctrine does or does not apply in your jurisdiction.
Thanks for listening to this episode of Subro Sessions. Be sure to listen to the next episode of Subro Sessions, which will be released on the third Tuesday of next month, September 17th in this case. You can find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com.
We would like to remind everyone that the contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with respect to any specific legal question you may have. The podcast should not be construed as legal advice for a particular situation or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome.